Most young parents think estate planning is something you do later, when you're older, wealthier, or closer to retirement. That couldn't be more wrong. If you have kids at home right now, estate planning isn't about how much you have, it's about who raises your children, who controls your money, and whether your family experiences stability or total chaos if something unexpected happens. You can be healthy, you can be earning well, you can have everything running smooth. But smooth today doesn't equal protected tomorrow. And if you've built strong income, a home, a family, retirement accounts, equity compensation, real estate, you've built something worth protecting. In this video, I'll show you exactly what would happen to your kids, your money, and your spouse if something happened to you with no estate plan in place. How that same situation plays out when you've planned properly, and a simple checklist every young family needs so you can protect your kids from chaos without overcomplicating this. A few years ago, I had a client whose husband passed away unexpectedly. They were young, kids at home, both in strong careers. Life was busy, full, normal, and then it wasn't. The loss was devastating. There's no financial strategy that makes that part easier. But here's what stood out to me. Financially, it was calm. Accounts transitioned the way they were supposed to. Life insurance paid out without dispute. The house didn't have to be sold. Kids didn't have to change schools. The wife didn't have to go back to work. She didn't have to fight with banks or wait on court approvals for what was actually hers. She had space to grieve, space to focus on her kids, space to think clearly. And that calm didn't happen by accident. It happened because years earlier, when nothing felt urgent, they handled the boring paperwork. They named guardians, they coordinated beneficiaries, and they put the right powers of attorney in place. Tragedy was unavoidable. Chaos was optional. So let's walk through what this would have looked like if they hadn't planned. And then I'll show you exactly what made the difference. First, let's talk about the question no parent wants to sit with for more than 5 seconds. Who raises your kids if you both pass away? Without a will that names guardians, the answer is not who you would want. It's whoever petitions the court. If both parents pass away and there's no written guardianship, a judge steps in. Family members can raise their hands, multiple people can petition, the court may assign a temporary guardian while everything gets sorted out. And here's the part that makes people uncomfortable. The judge does not know your family. They don't know your sister's values. They don't know your brother's financial situation. They don't know who your kids are closest to. They're making a legal decision based on testimony and paperwork during one of the most emotional moments your family will ever experience. That process can take weeks, sometimes months. During that time, your kids could be placed somewhere temporary. Maybe it's who you would have chosen. Maybe it's not. This isn't about drama. It's about default settings. Without written instructions, the state decides. Now, compare that to having a simple will in place. With a properly drafted will, you name the permanent guardian. You name backups. You can even leave a letter explaining your values, how you think about education, discipline, faith, structure, whatever matters to you. The court still formalizes the appointment, but they follow your documented wishes. There's no family guessing, there's no courtroom conflict, no scrambling to figure out what you would have wanted. Peace of mind here isn't emotional. It's procedural. You made the decision ahead of time when you were calm, clear, and thinking like a parent instead of reacting in crisis. And that's the pattern you're going to see throughout this entire conversation. Without a plan, decisions get made in court. With a plan, decisions get made at your kitchen table. Now, let's talk about money, because this is where even financially successful families get blindsided. Let's say one spouse handles most of the finances. They manage the investment accounts, the RSUs, the 401k, the checking account where the mortgage gets drafted. And let's say something happens to them unexpectedly. And keep in mind, this isn't just death. This could also happen if there was a serious injury or accident. Without coordinated beneficiaries, proper titling, or a trust structure where appropriate, here's what often happens. Accounts in their sole name can be frozen. The surviving spouse may not immediately have the authority to move the money. Probate has to be open. Court paperwork gets filed, and probate isn't a quick administrative form. In many states, it takes 6 to 12 months, sometimes longer. Fees can run 2 to 5% of the estate, depending on complexity and attorney involvement. Now, pause for a minute and think about this. The mortgage is still due. Childcare is still due. Groceries are still due. Life doesn't pause because paperwork is pending. This is what I mean by chaos layered on top of grief. Now, compare this to what happened in my client's situation. They had updated beneficiary designations. Accounts were titled intentionally. They had life insurance sized appropriately for their lifestyle. When her husband passed away, the life insurance claim was filed and paid within weeks. Retirement accounts were transferred according to the documents. She had liquidity quickly. She didn't have to sell the house. She didn't have to liquidate investments at the wrong time. She didn't have to go back to work before she was ready. Planning didn't make the tragedy easier, but it bought her time and space. And here's the bigger point for high-income families. If you've built meaningful assets like retirement accounts, brokerage accounts, equity compensation, real estate, you've built complexity. Complexity without coordination creates friction. Coordination creates continuity. Without a plan, money can get stuck. With a plan, money flows. But there's an even bigger mistake I see young parents make when it comes to money and kids. Let's talk about what actually happens if minor children inherit assets outright. On paper, it sounds simple. If something happens to you, your assets go to your kids. But here's the problem. Minor children cannot legally inherit money directly. If assets are left outright to a child under 18, the court appoints a conservator to manage that money until the child reaches the age of majority, usually 18, but in some cases it could be 21. That means ongoing court supervision, annual reporting requirements, legal fees, and a structure you didn't design. Now, fast forward. Your child turns 18, whatever amount is there. Let's say $200,000 from life insurance, $500,000 from investments, maybe more if you have significant equity compensation and real estate that was sold. All of a sudden, all this becomes theirs outright. No guardrails, no staging, no maturity tests. Now, I don't know many 18-year-olds who are ready and responsible to manage a large lump sum of money. Now, that's not a knock on them. It's just reality. Without a proper trust, you're giving up control. Now, you're losing out when distributions happen, what they're used for, how maturity factors in. Now, compare that to putting a simple revocable living trust in place when appropriate. With a properly drafted trust, you can stagger distributions, maybe age 25, age 30, or 35. You can allow funds for health, education, maintenance, and support. You can protect those assets from future divorce or creditor issues. Instead of saying, here's everything at 18, you're saying, here's a structure, here's guidance, here's protection while you grow into it. For high-income families, especially those with life insurance, significant investment balances, real estate, or concentrated company stock, this isn't theoretical. The numbers can be meaningful, and meaningful numbers deserve intentional structure. Now, here's something most families don't realize. Statistically, incapacity is far more common than early death. So let's talk about what happens if you're still alive, but you can't even sign your name. This is the part almost no one plans for. Imagine a serious accident, or a stroke, or another unexpected medical event. You're alive, but you can't communicate. You can't log into accounts, you can't sign documents. Now, without a durable financial power of attorney in place, your spouse may not automatically have authority to manage everything in your name. Banks can require formal documentation, investment custodians can restrict access, and in some cases, your family may need to petition the court for a conservatorship just to pay bills or make financial decisions on your behalf. That process is public, it's time-consuming, it's expensive. At the same time, without a healthcare power of attorney or an advanced medical directive, doctors may default to statutory hierarchies. Family members can disagree, major decisions can be delayed while legal authorities get sorted out. You're still here, but your family can't act clearly or quickly. Now, compare that to having the right documents in place. with a durable financial power of attorney, a healthcare power of attorney, an advanced medical directive, a HIPAA authorization. Your spouse can step in immediately. No court, no public filing, no delay. What happens is bills get paid, accounts get managed, medical decisions follow your documented wishes. That's operational continuity. And here's the blind spot almost no parent sees coming. The day your child turns 18, legally, everything changes. Even if they live at home, even if you pay their tuition, even if they're still on your health insurance. At 18, they're legally adults. That means you no longer automatically have access to their medical records. You cannot legally make medical decisions for them. Doctors, they may refuse to speak with you about their condition. You cannot manage their financial accounts without written authorization. Now picture this. Your 19-year-old is away at college. There's an accident. They're unconscious. Without written authority, you may not be allowed into certain medical discussions. You may not be able to approve procedures. In extreme cases, you may need to petition the court for emergency guardianship just to act. This isn't about fear, it's about awareness. The fix is simple. For children over 18, you typically want a HIPAA authorization, a healthcare power of attorney, and a durable financial power of attorney. These documents are usually straightforward and inexpensive to prepare. But without them, you are legally a bystander. And no parent wants to be a bystander in their child's emergency. Now let's pull this together and make this practical. If you're a young family building income, assets, and stability, here's the core checklist you need in place. Let's keep this simple. First, a will. This names guardians, directs how assets flow, and appoints an executor to carry out your wishes. Second, a revocable living trust, when appropriate. This can help avoid probate in many states, control the timing of inheritance, and add privacy. Third, a durable financial power of attorney, also called a POA. This gives someone authority to manage finances if you're incapacitated. Fourth, an advanced medical directive and healthcare power of attorney. This outlines preferences and names who makes decisions if you can't. And fifth, a HIPAA authorization. This allows access to medical records. But here's where a lot of families think they're done, and they're not. Documents without coordination don't solve the problem. You also need to update all beneficiary designations on retirement accounts and life insurance. Confirm contingent beneficiaries also. Review how accounts are titled. Make sure life insurance coverage actually matches your lifestyle and obligations. Store documents somewhere accessible and make sure the right people know where they are. And one important teaching point here. A will does not override beneficiary designations. If your 401k still lists an old college roommate from 2009 or worse, your ex-spouse, that's where the money goes, regardless of what your will says. Coordination matters. Now, let's address the practical question most people have. Do you need an attorney for this, or can you do it yourself? There are solid DIY platforms available online. For simple estates, minimal assets, clear family structures, no minor children, those schools can work. They're lower cost, faster to complete, and really accessible. But the more complex your financial life becomes, the more customization matters. If you have minor children, a blended family, high income, equity compensation, multi-state property, business ownership, an experienced estate planning attorney adds value. Not because the documents are longer, but because the structure is coordinated and state specific, designed around your actual numbers and risk exposure. The more you've built, the more intentional you want the structure to be. And let me clear up one final misconception. For most families, estate taxes are not the primary issue. Federal estate tax thresholds are pretty high. The real risks are guardianship, access, timing, incapacity, conflicts. You don't create a plan because you expect something to happen. You create one so that if it does, your family doesn't experience legal confusion, frozen accounts, and courtroom decisions on top of grief. Tragedy, unfortunately, may be unavoidable. Chaos is optional. Planning protects what you built, but building wealth efficiently in the first place, that's a separate discipline. Because I see something else happening with high-income families all the time. Income goes up, bonuses get bigger, equity vests, promotions happen, but saving rates don't always rise at the same pace. According to research, many high earners fail to increase saving proportionally as income rises. In other words, the higher the income, the more optional savings feel. The biggest deficiency I see with high-income families isn't bad investments, it's friction. Small behavior leaks that compound for years. We don't need better stock picks, we need better structure. So if you want to understand how high-income families can actually save and invest more efficiently without feeling restricted and without overcomplicating everything, watch this next video right here on how high-income families can save and invest more efficiently.